Good morning, Riverside. Thank you for taking the time to join us. We welcome you to our Modifying Your Child Support Order virtual workshop. My name is Sherry Bailey, Child Support Specialist. I have Marquise Howard with me, and I have Patricia Rich with me. Collectively, we all have about 25 years of child support service experience. Patty is from Riverside Superior Court Family Law Assistance Center. She has been a lawyer for 30 years, 20 of those years as a court attorney. Today we are going to answer a series of questions that help answer what is a modification, what's the process of modifying your child support order, and we are also going to detail what is the criteria needed to modify your child support order. First off, let's discuss what is a modification of your child support order. What does that mean? Do you want to take this one, Marquise?
Sure. Thank you, Sherry.
You're welcome.
So, a modification of your child support order is simply in a review based on what is appropriate, and that's determined on the guideline calculator. The guideline calculator, we will talk about that later on during this presentation, but we want to ensure that we have the right sized amount. We want to make sure that one parent's not paying too much or paying too little, but all of this is all determined on the guideline calculator, which we'll speak to more in depth. So a modification is simply just to modify your child support order to ensure that is the appropriate amount that should be ordered.
What is an RNA or review and adjustment?
That's a good question. So an RNA or review and adjustment is actually a modification. Depending on the county or the state, it's often referred to as an RNA or review and adjustment, but essentially it's a modification.
Thank you. Who can request a modification or a child support order? Patty, would you like to take this one?
Sure. Anyone can request the child support modification, either the custodial parent or the non-custodial parent. All you really need to show is that there's been a change in circumstance from the last time the order was made.
Thank you. What are the steps needed to request a modification? Marquise, would you like to help us out with this one?
Sure, not a problem.
Yes.
Well, one of the first things that's needed is timeshare, which is also known as visitation. So you need to know, have that information all documented as far as where the child is and who is taking care of the child and the time associated to taking care of the child. The next thing would be income. Mm-hmm. And after income, you would also need medical expenses. So if you are paying any type of medical expenses at all, please have that information detailed and have record of it, because that's what's needed. And the last thing is any type of hardship. So a hardship would mean a child, a minor biological child that's living with you. That is a hardship, so that could affect the modification as well. And I know that Patty is very familiar with modifying a child support order. Do you have anything else to add to that?
Yeah. Another thing that is taken into consideration when making a child support order would be child care. So if you have a child care expense, you want to have that documentation with you so that that can be included in the calculation. Also, if you'd like assistance to file your own request for order or to respond to a request for order that was served on you, you can contact the Riverside Superior Court FLAC, Family Law Assistance Center. You can either call us at 951-274-4499 or make an appointment under the Self-Help Child Support Assistance at riverside.court.ca.gov/appointments with an S.
Thanks, Patty. You can contact us at 866-901-3212, or you can go to our website at RivCoDCSS.com, and we have a great live chat feature.
Yeah, one thing that you should know about our live chat is you're able to do it on any device. Whether it's a laptop, a mobile phone, a tablet, you're able to chat with us directly. So if you are at home or at work or somewhere else recreating, watching this, you would be able to visit our website on the same device and chat with the live child support specialist. We're happy to assist and we're happy to help.
Another really good thing about the chat feature on the DCSS website is that you can speak to someone immediately. The offices are open, but you may need an appointment in order to speak with a caseworker directly. If you need immediate assistance, take advantage of that chat mode.
Thank you, Patty.
Because of COVID and the changes occurring, what if I now am homeschooling? Is this considered a custody or visitation change? Marquise?
That's a good question. With COVID, our lives have completely changed. School is done online. Distance learning is kind of the new wave. And homeschooling, some changes have happened over the past year. With that being said, the best thing you should do is contact our office. Each situation is different, and I want to make sure that I provide the correct information. So please reach out to us at 866-901-3212, or once again, visit our live chat and you're able to explain the circumstance or the situation regarding the homeschooling to see if it makes a difference in your child support order.
Patty, if my ex remarries, or even if I'm living with another partner, would this change my child support amount?
Not necessarily. If you or the other party is cohabitating without marriage, then it will probably have no impact whatsoever on your child support. However, if either of you get married, the effect that the marriage has and the household income has on your net income or that of the other party may affect your child support, because it is your net income that is considered. It is the parent's obligation to support the children, not the step-parent's obligation.
Thank you. My child support order changed. Who can I talk to regarding a change in my garnished wages? I am still garnished the same amount prior to the new court order. Marquise?
Sure. So if you need to update the amount of your garnished wages, the easiest method would be to contact our offices. www.RivCoDCSS.com, or once again visit our live chat, or you are able to log into Customer Connect and communicate with your caseworker at that point. We would be able to update that information with you as long as we know and you reach out to our office. One of the things that I think that are often left out is ensuring you know who your case manager is. Even if you're watching this video and you're unsure of who your case manager is, please feel free to reach out on live chat. Call the 866 number. Once again, it's 866-901-3212. Or you can use Customer Connect. Find out who your caseworker is, and that just is vital information for you to have.
With COVID happening this year and things constantly changing, can someone apply for short-term modification or a long-term modification? What are your thoughts on this, Marquise?
Well, I think it's important that if someone had a change in circumstances within the last 90 days, or at least up to 90 days, I think that it's important to just go ahead and request a modification.
Great. And you mentioned circumstances. What do you mean by circumstance?
Sure. So by circumstances, I definitely mean by a change of income. But then also, too, it could be a change of timeshare. So visitation might have changed. It could be medical expenses that might have changed. And Patty, do you have anything else to add?
There are also not only changes for you, but changes for the other party. So if you know that their income has gone up, you can also seek a modification.
That's correct. And then one thing, too, I want to mention is that if the request needs to be changed and the child support order is in a different county or in a different state, the process might change. So here in California, specifically, it is 180 days. It could take up to. However, if they are in a different state, then the timeline varies from state to state.
And if you can't wait that 6 months, and if you can't wait that 6 months, then you also have the alternative of filing your own request for order to modify child support, We can help you with that through the Riverside Superior Court Family Law Assistance Center. Again, you can contact us at 951-274-4499 and ask to make an appointment to speak with one of our specialists.
Patty, what exactly is the process in modifying a child support order?
When you go to the Department of Child Support Services, they will first open up a claim, send out the information, wait for the information to be returned, and then if the parties do not agree with the child support calculation done by the Department of Child Support Services, then a request for order or motion by Department of Child Support Services will be filed to allow the court to make that determination. The parties can also file their own paperwork called a request for order. The request for order can be prepared by the parties, submitted to the court, and you should be getting your hearing in approximately 45 days. The process, once you get your hearing, is that the attorneys for Department of Child Support Services will speak to you to see if you can resolve your case. If you can, they'll write up the agreement right there. If you can't, then you would go in front of the judge and allow the judge to make a determination as to your child support. Please understand, though, that the judge is mandated to use the California guideline calculator when calculating support. And they cannot take into consideration your hardships other than those that we've already discussed. As such, if at all possible, it is always in the best interest of the parties to attempt to resolve your issues of child support through settlement. This way, the payor has the opportunity to maintain their job or their living environment or make their payment on their car, while the payee is still able to get funds.
One of the forms that you mentioned was the modification packet. And I want to mention some items specifically in there. It is also referred to as a FL 150, and that's an income and expense declaration, and it has 4 key parts on it. One is the visitation verification. Second from that is the health insurance verification, child care verification, and proof of income. So all of those 4 items are needed in the income and expense declaration. On our website in the next few weeks, you will be able to see an income and expense declaration workshop provided by Patty. And should you need further assistance, you would be able to contact Superior Court of Riverside Family Law Assistance Center's website, and you'll be able to schedule an appointment directly with Patty to discuss some of these, the modification packet or any other questions should you have them.
And please be aware that the income and expense declaration is just one of 4 documents within the modification packet that you'll receive from the Department of Child Support Services. So the 4 documents that you would get include the income and expense declaration, the visitation verification, the health insurance information form, and the daycare verification.
Great. What is the timeline for this process?
Well, if you're going through the Department of Child Support Services, you can expect it to take up to 180 days or 6 months. It starts out by opening the request for the modification. Then the Department of Child Support Services will send out the modification packets to both parties. They have 20 business days or 30 calendar days to complete the forms and return them to the Department of Child Support Services. The Department of Child Support Services will then run a calculation based upon the numbers that appear in the packet. A letter will be sent out to both parties setting forth the amount that would be sought based on the numbers that were given. If the parties agree, then you may end up with a stipulation. If not, then the Department of Child Support Services will file a motion to modify the child support. It is here that the delay occurs because it can take up to 45 days after that is filed in order to get your hearing. The other alternative is to file your own request for order to modify your child support. By doing that, as soon as you file the paperwork, you can get your hearing date, which will be about 45 days out. The Family Law Assistance Center can help you with those forms and allow you to File them within a week of your contacting our office.
One thing I want to highlight too, the guideline calculator is actually on the state's website. And if you visit our website, RivCoDCSS.com, you will be able to, if you scroll halfway down in the middle of the website, you'll be able to click on guideline calculator. You have a chance to enter in the information there, so you're able to determine and see how we are able to calculate the suggested amount before the order goes out. So we use the same calculator and same information that you have access to. And all you have to do is go to our website and click on the guideline calculator, and you'll be able to enter in your information there.
And an alternative to that is make an appointment with our office, because we can run those numbers for you as well.
Great information. What if both parents agree to a specific dollar amount? So say the parties get the letter of findings and they agree to that amount, or they agree to a separate amount. What would the process then be?
Go ahead.
Then if there's an agreement, then the parties can contact Department of Child Support Services, and they will draft what we call a stipulation, which is a fancy word for an agreement, to that number. The parties can agree to any number they want. The court is obligated to make a child support finding based on the calculator only. As such, it really behooves the parties to try and resolve your issues without going to court. In an alternative to that, you can contact the Family Law Assistance Center, and we can also help you draft the stipulation to modify child support. The child support calculator will be attached to any agreement that you make. The reason for that is that the parties have to be aware of what they would be ordered to pay before they can say they don't want it or they don't want to pay it. I kind of equate it to informed consent. You got to know what you're doing before you do it.
Thank you. The other parent just had another baby by someone else. Does this affect my child support order? Patty?
It could. If the child is living in your home, then it may create a situation where the court would consider what we call a hardship. And a hardship would be the amount of child support that is being paid in the relationship at issue deducted from the net income. This might be the full amount or half the amount if both parents are working for the new child. Furthermore, if you are claiming the child on your taxes, or the other party is, that will have an impact on your net income, and that may affect your child support.
Thank you. Does a notarized agreement between both parties count as a valid child support order, Marquise?
No. In short, no, it does not. A notarized agreement does not count as a child support order. The child support order will still need to be modified by filling out the proper documentation and then going to court. And speaking of court, I know that Family Law Assistance Center is here today to explain the process of preparing to go to court. So, Patty, do you want to go ahead and discuss what's needed for going to court?
I would love to. Welcome to the Riverside Superior Court Virtual Learning Series, done in connection with RivCoDCSS. This presentation is preparing for your Department of Child Support Services hearing. My name is Patricia Rich. I'm a family law facilitator from the Riverside Superior Court Self-Help Center. Before we begin, I would like you to review the disclosures on the screen, which in essence say that while the staff at the Riverside Superior Court Self-Help Center consists of legal professionals, we are unable to provide you with legal advice. This presentation should be viewed solely as education. If you need legal advice, please contact an attorney near you. As a general overview, we'll be discussing how to prepare for your hearing, including where to find your call-in information, whether or not a response is necessary to the paperwork filed, and a general information on the income and expense declaration. We will then discuss how to file your paperwork with the appropriate proof of service. Finally, we'll discuss what you can expect at the time of your hearing. Step 1, hearing preparation. You'll need to review the notice you received from the DCSS or the other party and have the information readily available for you when it is time for your hearing. You will need to complete a response to the paperwork served on you, if necessary, and an income and expense declaration. It is important to remember to provide your last 2 months of pay stubs and last year's tax return with your Social Security number crossed out so it cannot be seen on the document. Your notice to provide the income and expense is found on the short form after hearing. You are to file and serve this document at least 10 days before the hearing. While the order requests that you bring your latest federal tax return to the hearing, all hearings are currently being conducted telephonically, so you may want to submit this document with your income and expense declaration to ensure that the information is received by the DCSS and the court. You also received a notice of court hearing. This notice provides you with the date and department for your hearing and the appropriate call-in number. Please note that the notice requests that you leave a message at 7 a.m. The Riverside Superior Court Self-Help Center's contact information is also provided in the event you need assistance preparing for your hearing. The response to the government notice of motion is filed for a hearing filed by the Department of Child Support Services, or DCSS. The responsive declaration is filed in hearing set by the other parent. These documents are only necessary if you want the court and DCSS to be aware of information that is not already found in your income and expense declaration. For instance, if you are currently not working, you may want to explain why you're not. If you have a greater timeshare than what's indicated in the moving papers, you may want to provide proof that you are seeing the child more. Please note that for the purpose of determining child support, your expenses are not considered to any great extent. The first page of this form requests information on your employment, education, tax information, and the other party's income. On the second page, you'll provide your income from all sources, third parties, investments, self-employment. You'll also provide information on what assets you have that can help you pay the bills. Your bills or budget is requested on page 3 of the form, including your credit card, auto payments, and student loans. The last page asks you questions related to your children. You estimate your timeshare with the children or provide their schedule of visitation, set forth the costs you have associated with those children, and if you suffer from any hardships that may reduce the net income when calculating support. A more thorough examination of the income and expense declaration can be found on the video completing your income and expense declaration. Step 2 in the process is to serve the paperwork on the other parent and DCSS, and then file the paperwork with the court. You can serve the paperwork on the other party by either having someone 18 or older who is not you hand deliver the paperwork that you'll be filing to the other party or mail the paperwork to the other party. Then complete the proof of service by mail or personal service. To serve DCSS, you can email a PDF of your documents to serviceportal@rivco.org. Once the person has mailed or hand-delivered the paperwork to the other party, they will need to complete a proof of service by mail, Form FL335, or proof of service by personal service, FL330. On the screen, you'll see the proof of service by mail. It'll be necessary for you to complete the caption at the very top of the screen. Then the address of the person who mailed the document will appear at number 2. The documents being served, namely the income and expense declaration and response, if you did one, are listed under number 3. You'll also indicate if the documents were mailed by placing the documents in a mailbox or if they were mailed from a business who has a regular course of action related to mailing of documents. At number 4, the person who mailed the documents will provide their name and address of the person to whom the paperwork was mailed, the date it was mailed, when they mailed the document, and finally, the person will date, print, and sign the document. The documents need to be filed with the court before the hearing. Remember, these hearings are currently done telephonically, and any information you want the court to see must be submitted to the court before the hearing. This can be done by mailing the documents to the address provided on the screen, dropping the documents off at the court where your case will be heard. Don't forget to include a returned self-addressed stamped envelope so your documents can be returned to you. Finally, you can e-submit your documents to the court's website at riverside.courts.ca.gov. You can find the e-submit link under the online services. You will be taken to the e-submit page that includes useful information on how to e-submit your documentation. The last step is to attend the hearing. Before the hearing, you may receive a call from DCSS in an attempt to have the parties resolve their issues before the hearing. The hearings are currently conducted telephonically. It is important that you call in on time. You'll leave a message with a return number so the DCSS attorney can contact you. Once the case is ready, the DCSS attorney will call the parties on a conference call to discuss the facts, such as income, timeshare, stress the importance of settling out of court, and if no agreement can be made between the parties, then the matter will be set for a hearing. If your case is not submitted to the court by 11 a.m., your matter will be scheduled for another day. This shows the importance of both parties calling in on time so that you have a better chance of getting a same-day hearing. If you do not get a same-day hearing, If you do get a same-day hearing, you'll be instructed to call back at 1:30 p.m. and wait for your matter to be called. After the hearing is concluded, DCSS will submit an order after hearing, setting forth the terms of the agreement entered into by the parties or the orders of the court. It is important to follow the agreement terms or order of the court immediately and not wait for the order after hearing to be received through the mail. This concludes our presentation on preparing your child support hearing. If you have questions, would like to have your child support calculation run, or need assistance with your forms, please contact the Riverside Superior Court Self-Help Center to make an appointment. You can also make an appointment on the web by visiting https://www.riverside.courts.ca.gov/appointments. Our staff is available Monday through Friday from 7 a.m. to 4 p.m. to assist you with your child support needs. Thank you for joining our presentation. I'd now like to return this presentation to Sherry.
Thank you for joining us here this morning. We hope that you've had some valuable information about modifying your child support order to be used in the future. I'd like to thank Marquise and Patty, and I'm going to ask Patty to share again the information for FLAC.
You can get information regarding the Family Law Assistance Center or Self-Help Center by visiting our website at riverside.courts.ca.gov. On the screen, as you scroll down from the home, you will see the Self-Help tab. You'll press on that, and that will take you to another window, and you will select the Family Law Self-Help. From there, you will have the option to look at our workshop calendar, to look at our form packets, and to get additional information regarding issues in your case. If you need to contact us, you can do so by contacting us by telephone or through our website as the appointment scheduler. Our phone number is 951-274-4499. You can also call 760-393-2163. That's for our Indio court. Furthermore, if you need to speak with someone and would like to make your own appointment, you can do so by contacting us at riverside.courts.ca.gov/appointments with an S. Marquise?
Well, one of the things that Patty mentioned is appointments, and we have the ability to make appointments on our website as well. So if you want to speak with a child support specialist and you want to do it on a time that works better for you, you are able to make an appointment. And also we have Skype video appointments, so you never have to leave the house. You don't have to come into our office. You're able to communicate with a child support specialist on video. So definitely go to our website, RivCoDCSS.com. At the top menu, you'll be able to click on appointment, and from there you'll be able to schedule an appointment. Also, I encourage you to follow us on social media. Like our Facebook page if you haven't already. Follow us on Instagram and on Twitter to find out what we have going on. Upcoming in November, on November 19th, we have a stipulations workshop. And stipulations, as Patty mentioned earlier today, is another term for an agreement. So we have an agreement workshop that's going to happen on November 19th, and that will be at 10 a.m. And last but not least, I definitely want to encourage you to subscribe to our Coffee Break podcast. We have hosts Nathan Hartel and Bruce Wagner discussing a variety of topics regarding Riverside County's child support programs and services. I appreciate the time today, and
Thank you, Riverside, for joining us today.
all right,
Thank you.
thank you.